She said she'll do everything that she
Then,
can.
I mean, we'll just keep going. I mean, I guess, so to speak, right? Until she gets the money that she's,
So she is enrolling and going to the IOP, but the provider told me she was supposed to finish on February 18th, but she advised him that if she's struggling financially, he said he will talk to her and see what they could do to work on these, but they won't release the certificate until everything is.
But she is attending, because whenever we had the issues back when.
Okay, pause. This is where things get interesting. What would you have done in this situation? Drop your thoughts in the comments. And if you're hooked already, make sure to hit like so more people can join this breakdown.
She just needs, how much time do you need to? Can she focus on paying the IOP SOP so we can get those certificates and then we'll figure out the devices? Or would you be willing to get rid of her income monitor? That's like $350 a month. So maybe she can take that money and put it towards the IOP SOP classes. We haven't had.
you have now.
You have the in-car as well, right? Mm-hmm. She has the in-car and the income monitor.
Then the problem is I'm never going to know whether she's using, and the only time is whether she's in a car, and we can't trust her though, because we've tried this.
Maybe you couldn't trust her a few months ago, but she's been good. She's been really, really good. She's been coming to court. Remember, she was coming to court every week and then every couple of weeks, and now she's coming once a month. Yeah. So she's been doing great. So I'm just trying to figure out a way to.
How do you earn money now?
Well, I'm a full-time student, so I don't.
Where do you go to school?
I go to both UH and Lone Star. I take dual classes.
So how do you survive now? Because you still need money.
She's with her parents, Judge.
Sorry?
Oh, for my classes, or
no? Judge is asking you what do you do for money? Who gives you money to
Still
drive?
need to eat.
My parents.
Do you live with your parents now?
Yes, my mom.
The problem is that we've tried this before, and every time we let her, we give a little bit of leeway. She just picks a yard every single time, and we've been dealing with now.
No, Judge, you say every single time, but we've had one time. This has happened one time in the past. So this is when we had the issue.
Ramirez.
It hasn't been multiple times,
You've been
Judge.
dealing with this for 825 days.
Yes, because the case was older. I don't know if you remember, she was ready to be done, close to being done, and then she tested positive that time. Then one time, she tested positive. It was just a high positive, but it was a one time. And that
It was like multiple skip stuff, wasn't it?
She was admitted to using alcohol. I think she went out for her sister's birthday.
right, and that's the one time when she tested positive. And then we came before you, and then
Ones that we know of, right?
what, Judge? No, that doesn't mean that she did it multiple times. There's a one violation.
But I don't know, and I can't.
But then we can't make the assumption that she did.
So if we were to take it off, is she reporting? Where does she report to?
She's reporting to the probation office.
So could we do, if we were to take it off, we do enhanced, like a lot more.
Or Judge, another option, if you're open to it, put her on a blow schedule for her in-car. And then you have her monitored if she's on a blow
It's a
schedule.
great idea. Can we
And
do
that
that?
way we can get rid of
It's a
the.
great idea.
So she doesn't have to come
No,
for
that's
our
a great
hearing
idea.
and all that.
I'm happy to do that. I don't know why it didn't occur to me about that, but yeah. That's a good idea. But I want, I don't care if we're telling you to blow at midnight, you have to blow at midnight. If you come up with an excuse, well, I can't do this, you know what excuses mean? They go in one ear, they go out the other. I don't care for excuses. Do you understand?
Yes, sir.
So, this is absolutely no tolerance. Okay, so let's do that. We'll do,
Remove the ankle monitor, but if she doesn't come up with the money by the 18th, she said she'll do everything that she can.
we'll just keep going. I guess, so to speak, right? Until she gets the money that she's, the incentive there is to get the money as quick as possible because you want to be done with this, don't you? So, right. All right, so we need to craft a blow schedule because I also want her blowing not only at midnight, but, Okay. All
Thank you,
right.
Judge. Okay, have a seat, I'll come talk to you.
Good morning.
Approaching on Mr. Kabir, Kabir. So He's here on a bond violation, and also, we were gonna set this for trial as well, Your Honor, two separate matters. It's a Scram violation, on January 16th and 17th. It's labeled as his third, Your Honor, but I think it's technically really his first that it's had alcohol detected, because the prior bond violations have been, I guess, like he wasn't using his car enough, so the battery would shut off the IID. I would ask the court to take that into consideration.
So the first time he was in lockout, so it wasn't getting,
Yeah. I'm just saying this is the first bond violation that's, alcohol's been detected, Your Honor.
Felicia,
Yes, Judge.
on Mr. Kabir, the fees are waived, no?
There should be, yes, I can double check for you just.
So how does it go in lockout? Because it says client,
Check into the recalibration. They're instructed to report to the vendor. I believe it is.
no. It says here, as of 8/11/24, client's ID has been in lockout due to non-payment
Let me double check.
and failure to report, but I waive everybody's.
Yes.
And Your Honor, you're saying that,
Come up, Mr. Kabir.
According to the conditions of bond, they are waived. It's very clear that they're waived according to the bond conditions. So I'm truly not sure what that is. I can reach out to the case manager further. Maybe there was like a mistake.
So what's going on now with Mr. Kabir? Why do we have yet another bond violation? I mean,
well, Your Honor, it looks like this one, is for alcohol consumption. That was, on the 16th through the beginning of the 17th.
right now. And then I'm gonna roll up to tomorrow. I'll see you, Mr. Kabir.
And, Your Honor, since we're here, it seems like, the offers, from the DAs, have been exhausted, so we're ready to, set this, case for trial.
I want to have a hearing on his, whether, I'm setting it for a test.
Sure.
Roll it to tomorrow.
Okay.
I want to have a hearing on it because, I mean, it's just too many
I
violations
understand, Your Honor.
and things.
Sure.
Just too much drama, Mr. Kabir. No. All right, I'll set it for tomorrow and then I'm sending it for a test now. Okay, thanks. Hi.
Good afternoon, Your Honor.
Hi.
I'm pushing on my client, Mr. Kemp.
Okay.
I wanted to.
It was our understanding that you didn't put any bond conditions on Mr. Kemp.
No, I want, do you have
Define
any,
PC on this case?
do you have any argument?
I do.
Tell me. So, refresh my memory because I don't
This is
remember.
where, my client's mother was having like a heart failure.
Oh, that's right. Okay, so moms
EMS
have,
was called. He called EMS, right?
wait, who,
To my client. His mom called.
she has a medical episode. They're trying to administer.
Trying to get her to the gurney, and someone's trying to get to the side of the gurney and replace a family member, and then that EMS is grabbed by the arm by the defendant.
At the time, he was emotionally distressed due to his mom's medical emergency. It was more of a protective action. It wasn't any type of, there was no clear harm to the EMS. I mean, when we look at this,
Stop. Don't.
All right, go ahead and sign.
You're saying he prevented an EMS worker from,
Performing their duties and getting to the gurney to assist the mother, because she was on the gurney, and while she was trying to replace a family member who was on the side of the gurney assisting to get to the gurney, he grabbed the EMS worker and said, specifically, nah, don't fucking, until the officer pulled him away. He was holding the person until pulled away by the officer, and he said, nah, don't, and then the officer grabbed him and took him to the patrol vehicle. So he was grabbing onto the EMS worker as she was trying to assist him.
I think that statement was based off of a little bit of confusion and frustration. It wasn't his intention to like impede
And
on the medical assistance.
in this case, that impediment would be grabbing the EMS, so she couldn't, or the EMS responder couldn't perform their duties, because at the time the defendant had grabbed their arm.
what was EMS, what were they trying to do?
So according to the DIMS, it says EMS responder tried to replace the family member that was assisting on the left side of the defendant's mother. So they were trying to take that position.
Okay, Right.
So they're trying to assist the mother who was
Okay.
on the gurney. And that's whenever they couldn't do that.
Keep going.
And then it says the defendant proceeded to grab EMS responder's right arm and stated, "I nah, don't fucking." Before the defendant could finish, the officer used an open hand technique to separate the defendant from the EMS responder.
Do you believe that arise to a clear threat? Or I think there was a lot of confusion because it seemed like two of his family members were.
What is the intent of what he is trying to do?
So
Is
there's
he-
a backstory to this because which he can explain as well, because it's a bit confusing, but
But we really can't get into that.
yeah, I know, I can't get into
The
the
thing
backstory.
is he really trying to impede? Is he trying to help?
He was trying to, so his situation was trying to help because in a way, he felt like they weren't trying to assist in the way in which they were called to assist. So it was more confusion because based off of what my client's telling me as far as these facts
You're wrong.
that are stated.
As pled, it's through criminal negligence that it's just disrupting or impeding. And in this case, it was because the EMS could not replace that family member to get to the mother who was on the gurney. Because at the time, she had her arm grabbed by the defendant. So whether or not he intentionally was trying to impede is not the question, it's whether or not there was that impediment due to some criminal negligence. In this case, there was.
But what would you define as a criminal negligence?
He should have known that they were trying to do their duty and not to get involved.
And is it a public official? Is it a,
And allow me to pull up the information again. And as pled and reflected in the statute, the person employed to provide emergency medical services, including the transportation of ill and injured persons. So in this case, it was the transportation of injured persons.
Can we, because I would definitely like to put everything together with the facts by watching because obviously there's camera to show exactly what happened, right?
I can see it.
Wasn't there dash cam?
do you want to delay it a couple
Yeah.
days?
There's a lot
I'm
of
done.
videos. Yeah,
There's a
they're all
lot of
there.
videos, so I can look at the videos and then put the pieces together to see
So,
to see his clear intentions.
Pick a day later this week and we can have a problem.
Okay. He does need bond conditions, though, Your Honor.
I wasn't going to put any conditions on.
Okay,
I mean,
that's fine. Well, that's fine for me and my client. I just wanted to,
Yeah.
that's what he's waiting for.
okay. We have this young lady that's about to plead to the case. The problem is that she's got 5 kids, can't afford anything. Is there a way to waive all the stuff in the program?
Because a lot of those costs are community supervision costs, and I don't have the authority to waive their costs. So like SOP, I don't know if she's taken a TRAS yet or anything, but SOP,
She's, how far along is she in the program?
I think 3 or 4 months in.
has she spoken to the probation officer about her financial situation?
Well, we originally filed a financial affidavit, and then as far as conversations with her officer, she had made mention that she can't afford it anymore. Basically, at that point, she stopped doing stuff because she can't afford to do it.
Because typically my understanding was that if she brought that to their attention, they would go through and do kind of a financial plan with her and help her find lower cost options.
I think she wants to do
But I'm
that.
not sure. So she's already in the program, correct?
Yeah,
Okay.
yeah.
And she's on docket for a violation or something?
No, she wants, she's going to plead today because she can't afford it.
Yeah, I was going to bring her in to plea it out because she can't afford it.
Would you mind emailing me her case information? Allowing me to staff it with our program coordinators who can reach out to her specifically assigned officer to see what conversations they've had and what
Okay,
options
sure.
are available to her. Before she makes
Does she still want to do that, you think?
She wants the case off the record if she could stay in the program. It's just a matter of finances with her.
So let's see, let's not do it today. Give it some time, see if you guys can work it out.
Yeah,
you
she's
know?
not on docket today, so we brought her in off.
Oh, okay, great. Yeah, then just,
She lives in Louisiana, so she got,
oh, that's another hurdle too.
How long is she here?
well, she's going back right after court. I mean, yeah, that's where she lives.
I mean, we can always do stuff through Zoom,
Sure.
so, or FaceTime, so there's always a
It's
way.
true, yeah. If we're not gonna plead, we can do it.
Please, she's got to be here.
Yeah, I understand that.
Everything can be achievable through Zoom. There's just
She
no,
wants me to look into it. I have no issue looking into.
I'll email you everything. Then, if we could find a solution that works for her, I mean, that'd be great.
awesome. Yeah, We need to be able to, there should be a way that we can work these things out. Like maybe we get some like grant funding or something to where when we have people who are in this situation, I don't know. I'm just thinking out loud. But, because I know, and I know.
That community supervision might have access to those kind of resources. I just know it's something the state does not.
I want to say that I've heard that other jurisdictions also have a way that they have a workaround in these situations as well too. So,
Most people, what they do or don't have,
right.
not want it to be available to everyone. So we'll get to the bottom of it.
Okay, cool. Yeah, just let me know if you ever need anything and then I'm.
Thanks, Judge.
Good morning, Mr. Osores. Good morning. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 6 days in jail with credit for the 2 days that you've done. You need to understand a couple things, sir. Number one, that this charge is going to go on your record. It's going to be there for the rest of your life and you can never take it off. What that means is that whenever you get pulled over now, in the future, an officer, the first thing they're going to do is they're going to look at your record. They're going to see that you have a prior DWI. What do you think they're going to do if they come up to you and they smell alcohol on you? No.
Oh, no.
Shoot again. What do you think they're going to do? That's what's probably going to happen. Right. What we're doing today, from now on, you are facing a minimum of 30 days in jail. No more proverbial slaps on the wrist. What's more is you're on felony probation. For a is it a third degree? It's a third degree, right?
Yes, Judge.
There's only so many times that they're going to let you slip before they put your butt into prison. What do you think they would do to you in prison? Do you have any clue what they would do to you? It's your worst freaking nightmare. It's worse than that. And you're literally. If you have a problem with drugs or alcohol, you better address it before the felony court gets involved and really takes your life for a spin. Because there's only, like I said, there's only so many chances they're going to give you before they light your butt up and just throw you into prison. Once that happens, your life is all but over. Anytime you have a felony conviction on your record, your life is all but over. It'll be nearly impossible to get a good job. No one hires felons. Potentially lose the right to vote. It is a very bad thing. So you're telling me that they're going to continue them on supervision upstairs?
The whole deal was, as long as we pled to something here, and they were going to continue them upstairs. And we just wanted to get it done before he asked court on Wednesday. We were just waiting for videos to come in, so we reviewed everything.
So you have to understand, you're on felony probation. You plead to this case, it's very possible they revoke your probation, put you in prison. Do you understand that?
Yes, sir.
You give up a lot of rights by entering this agreement, Mr. Osorio. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty to this offense, like I said, it'll go on your record. You can never take it off. Do you understand?
It's just,
We all make mistakes, right? But the idea is that you learn from your mistakes and you don't continue to endanger other people's lives. There is a $3,000 surcharge that is usually tacked on when someone pleads guilty to the DWI. I'm going to waive it now, but I'm going to tell you on the second offense, you're looking at a $6,000 surcharge, not to mention court costs. So get ready. You pick up another DWI. It's really going to go south. Do you understand?
yes, Judge, thank you.
I am going to suspend your license for 180 days. Do not drive until you get a license. How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty, sentence you to the agreement. Good luck to you, sir.
Good excuse, Judge.
You got it. All right, we are done.